Evening, everyone. Hope you're doing well. We already met before a few times. My name is Victoria Zigopikowska, and I'm the founder of Victory Art. And today I'm very excited that we're able to have another of our sessions. And this session is very special because it's with our last partner. You did not have a chance to meet yet. And the name of our partner is Paulina from GJW. And she's going to talk about very important legal stuff which are connected with art and being in art industry.
I will start with introduction. You just already introduced me, and I will do it a little more here, but I will try to share my screen with you first, maybe, so we could try to reach everything that I prepared for you this evening. Okay, so as while waiting attorney at law, this is my legal profession. I am also a member of the partner of Georg Legal Office, and simultaneously, I'm also the member of the team that is running the Georg Gallery, that is internet interpretation, and this is a joint project with our artist Igor Morski and a graphic designer and the Georg Legal Office. Today I prepared the webinar regarding protecting your art and legal guide for the artists. So that's my title that is provided for this evening. And this is the second edition of the legal webinar I do with Victoria, and I do with Victoria Art. And since the first edition I was trying to show and I was trying to explain as well to the artists and discuss them how the law can help them to protect their rights and also their work, and how it can effectively manage, they can effectively manage their career. So the goal in this time, in this session for me, is to provide you the same legal information with more, let's say, practical legal knowledge. It's obvious thing that as an artist, your work is valuable, and not just in a creative point of view, but also from legally and financially point of view. And whatever you are, painter, graphic designer, illustrator, or just any other kind of creator, this webinar will help you to avoid common legal issues or problems or pitfalls maybe. And hopefully after that, at the end, you will have the clearer understanding of some legal terms and legal constructions, and you will at least recognize what is on your side, what are your rights and what are your obligations, and negotiate better contracts, or at least understand them, and take any other legal actions or other actions that will effectively help you and protect your work from misuse. And I am aware that the law may seem complicated, of course, and it actually is during my profession, my everyday cases. But the basic understanding is essential, and actually this is all that we need here in this time. So the basic understanding, I believe, can avoid issues such as unfair use of your rights, and, for example, help you in the case of unfavorable contracts. So this webinar will be focused around Polish law, basically, because I'm a professional in the Polish law, and I work in this jurisdiction only. But I also have some knowledge about the other countries. But generally, the topics that we will discuss have universal relevance, and I believe that they can help to understand and can be helpful regardless in what country you operate in, what country you work in, whatever, if you have trans border actions or working, it should be really helpful. So yeah, having that quick introduction, let's say, after I did the introduction, and introduction is done. And today I prepared for you two basics stream of knowledge. Let's say I would like to discuss, to tell you about in a brief way that I could, to be more understandable for you if you are not lawyers and professionals. And one stream is the copyright law, and I would like to discuss that issue. And also, I picked for you for today's webinar the issue regarding with the contracts in the art industry. I would like to tell you more about how to create one, what's the difference between them, and how can it protect our laws in a contract, and what else can we do if somebody is, if we see any infringement of our law. Yes, let's start to look at the basics of copyrights. At the beginning, just quick reminder or quick definition what the copyright is, and yeah, every block of information that I produce for you will have some more specific points, and also copyright law will have some information here that I prepared. And generally, I'll be talking about the definition of the copyright law, and I will tell you a little bit how to protect it and what rights do creators have. So I'll give you that's two types of the rights, and I will tell it a little bit more about this. Some information about the lasting of the copyright protection, some hints about automatic protection, and I think some interesting information will provide you both two last points. So how to prove your authorship in case of any dispute, because this is very much particular practical information and also examples of copyright. I will start probably from the umbrella term that is intellectual property rights. So that's the aim of the target that everybody is common with, and everybody, I guess, recognize it. And the copyright is the most popular form of the intellectual property right. So that's the white umbrella, and here we have like a little string of it in the intellectual property rights. So this law, copyright, is a foundation of legal protection of the creative works. So I will show you the detailed legal breakdown of the fundamental principles of the copyright law and what to do with it and how to understand it and how to protect it. So what is copyright? This is the legal framework, very basic, that protects original creative work. And it grants the creator who made the work exclusive right over the work. And on the other hand, it prevents others from using it without the permission of the author. So that's the key definition of the copyright. And we start with this one and go to the subject and object of the copyright. So what actually does the copyright protect? Well, as I mentioned at the minute before, it applies to the works that are original. That's for sure. It means that it is created by the human, and with some certainty or certain degree of creativity. and this work has a flex or tangible form. So we have to have like some medium. So I don't know, digital file or Canva, anything that is visible to the other person. And okay, and of course we have like plenty of examples to protected work, and it includes visual art, paintings, drawings, photographies, sculptures, every other form of creative that you can imagine here. Maybe it could be combined art, whatever. You have music, you have compositions, lyrics, and you have literature work, books, poems, scribes, and everything that is that show and form the creation by the human. And also digital content. Every digital content could be the subject of object, I'm sorry for the copyright. And who is protected by copyright? We have a subject of copyright right now. So basically, the one who is protected is individual artists. Okay, so that's creator, artist, photographer, painter, musicians, writers, designers. All of this individual entity is protected. Also, their heirs or successors that are that stays after artist's death is also the subject of the protection of copyright. And on the other hand, we have like multi-member entities like companies, organization, any kind of them, foundation, any other entities that also can be the owners of ownership of the copyright and also are protected in this matter. I assume you as an individual artist will refer to this part of the copyright and you'll be most interested in this area. And of course, copyright has its limits because it do not apply to every aspect of art, and they do not apply to the ideas, to the concepts, to the methods, to the facts that are commonly known. So only expression of that, all of this, so of that ideas is protected. So it must be tangible, as I said before, and also the works that are in the public domain are not the subject of or the object of the protection because their copyright has expired, and that's why they are in the public domain, or the work is free for public use. It's also possible in the public domain. Okay, so that's the definition of copyright, to give you the highlight how to understand it and how to cope with this. And we could just smoothly pass to the second point. What rights do creators have? So basically, once the artist creates a work, they gain two types of rights, and it's moral, personal right, and economic rights. This is very basic division between those two, and these rights, moral, personal, and economic, differ. They differ very much, and in a legal point of view, it's crucial and it's very important because they can be used in a different way. They can be transferred, or they cannot be, or they sometimes can be waived. So starting from the first one, which is moral or personal right, they are not basically, but they are from the beginning, they are non-transferable. Okay, so the moral rights protect the personal connection of the author with his work, with their work. So this is something very individual and personal that cannot be changed, that cannot be taken away. Is the very basic law here and the right here. And the moral rights in practice means that the artists have a right to attribution, so he is always shown as a creator of the art of that piece of work. He has a right to integrity. It means that his work cannot be changed without his permission. He has a right to decide on the first publication. So when he want to show the work, when he want to publish the work. So these are moral rights occurrences, and they stays with the author. And on the opposite side, the economic rights. These are the rights that are transferable rights, and I believe they are situated like that in the Polish regulations, and the regulations in the European Union. So I believe any country like Czech Republic, like Hungary, like Slovakia have the same regulations here. So it works like the universal rule. And economic rights, transferable, as I mentioned, give the artist the control how his work is used, how it's distributed, and how it's monetized. Okay, so this is the part that can be transferred, that can be sold, that can be licensed, basically. So, and within this economic right, we have right to reproduce. So it means the exclusive right to create copies. We have a right to distribute. So we have the right to sell and rent and do all that kind of stuff with your work. We have a right to public performance and display. So you decide where you want to use it and where you want to show it. And we have a right to adapt and modify your work. And whether economic rights can be transferred, yes, of course, these rights can be transferred. I already told about it, some information, and it's the payment involved in this transaction. And regarding the Polish regulation, it needs to be paid for the transferring the economic rights. So, so this is very crucial information and important. They can be sold. Of course, the copyright agree assignment and license. Yeah, they can be sold. So it means that artists permanently transfer the ownership to another party, and also these rights, as I mentioned before, can be transferred. It means that license. I'm sorry. So it means that owner of the right artist retain the ownership, but he grants limited permission to use the work under specific conditions. And these are two key differences between the solution or transferring these economic rights. It can be sold as a whole. You just transfer from one person to another, from artist to another person that is interested in, that want to use it, or you can license it so it stays with the artist and he just let some other party to use some part of his rights only on certain conditions. For example, let you, or is it able to, you are able to show it in some certain situations or circumstances, not in the other. So yeah, the two key legal differences between the rights that creators have are that they are non-transferable or they are transferable, and they last indefinitely, or just can be sold or licensed. And yeah, and I also mentioned about the company own. Yeah, also a company can own these rights, but the company do not own moral rights. In Polish regulation, we have the situation that that moral rights cannot be transferred. but the artist can agree not to use it. Let's say we have some kind of a regulation like this. Okay, and how long does copyright protection last? It's usually 70 years after death of the artist, and of course during the artist is alive. And what happens if the rights is expired? I just said that it goes to the public domain when you do not need any permission to use it, or it is open to free use. Everyone can just freely use it. And just the quick examples of a public domain, it's the works of our Asian painters or classical musical composers. All that stuff is put it in the public domain work when it's free and open and can be used by the public. What is also very important legal information regarding the copyright is the automatic protection versus the need for registration. It needs to be pointed out here that yes, copyright protection is automatic, and in most jurisdiction it works like that, including Polish one, including the jurisdiction over the European Union. So it means that as soon as the artist create the work, the art, the piece of art, painting, photograph, sculpture, anything that you would imagine, the work is automatically protected by law. It's construed like this, and generally, just the key legal principles here is no formalities are required. You don't have to do anything. You don't have to register it. Okay, you have protections by prepared and protected that is stated in law. And you do not need to do any legal actions. But of course, we have to remember, as I said at the beginning, the work must be original, must be created by the human, and must have the unique character and be result of the creator's intellectual effort. That's the definition of the creation. Okay. And also have to be in fixed, tangible form that I could say, okay, this is my painting. It looked like this. It has that shape and it has that structure and colors and so on. So that's really important. And yes, of course, we can register what we create. You have trademarks. You have design industry that is also covered. So. Yeah, you can use the National Patent Office. You can go and say, this is my trademark, this is my design, this is my online design, and I want to protect it. But it has certain conditions. You can also use the European Union Intellectual Property Office for trademarks that are supposed to be shown in the European Union territory and also have the protection on the European Union territory. Yeah, but it's usually connected with the patent, with the trademarks and so on. Of course, every time you should prove and you should have to have the ability to prove the ownership in a court or in any other dispute or in any other situation. So yes, in one hand, you do not have to register your copyright. The other hand, you can do it. So we can think and we can discuss right now what to do if I cannot register my copyright and whether I am sure and I will be protected then. So, well, yes, legal solutions are also prepared in this situation. So we have some ways to prove the ownership and to show the other parties that we are the author of the work of the creation, if it's needed. So when this dispute arises, and this is the basic and general legal rule, and of course, it will be presented and probably is presented by every lawyer that will work with the case. that, but this also is related with copyright. When the disputes arise around the copyright ownership, because we are in this moment here, the burden of proof, falls on the claimant. It always works like that in legal procedures. So the artist who claim that is the author of the work will have to be prepared in the case that his work will be stolen, copied, anything like that.
Paulina, we
So,
have 10 minutes left, just to inform.
okay, great. Thank you. It will be helpful. So we can have some types of evidence to prove the authorship. We have metadata, timestamps regarding the digital created piece of art. We can email our staff our work, copy of our work to our self email address that we can prove the date of the creation. Of course, we can write a contract and we know that we are the author of the work and we know the date. We can make a public exhibition and it also shows the date that we put our work on the public. We can also go to the notary and say that this is my work and please give me the statement that you take it and you give the date. So quick look at the examples of copyright infringement. I'm sure everybody is aware of this, and I'm sure that artists frequently encounter situations where the works are copied, stolen, anytime used without permission. It could happen not only in the internet. So basically it's unauthorized reproduction and distribution. So when the company prints and sells the T-shirts, for example, with your artwork, of course, it's a plagiarism and direct copying when somebody is taking your work and saying he is the artist, not you, instead of you. We have also the uncredited use of your work in commercial projects. Online content theft, that's very popular regarding the internet, is worldwide and it's a huge medium of every information. And also very popular in last time, AI generated art theft when your artwork could be used as a train to AI model. That also can happen, and you have the way to respond as well. You can protect yourself and you can respond to it. You can make legal actions. You can start to do it by your own. The most important thing in that situation is that you are aware at least what is happening and how you could move in one direction. So the basic direction is that you will negotiate or you will try settlement with the person that is infringing your rights and is taking your rights to the work or to the creation. You can of course start to correspondence with that person. You can send the cease and desist letter, so you can form the legal information to stop the infringement. You can also make some takedown requests using the platforms, online platforms, when your works are or they are existing. And at the end, you can of course initiate the legal proceedings by your own, as well as with the help of the lawyer. So, okay, 10 minutes left. I'm sure I can. I will manage to go through.
We have like 6 minutes left now.
Great. Okay. So contract in the art industry are very important. Everybody in some time has a connection with the contract. We will have to sign it or we will have to agree to this. And yeah, we have like situation that contracts plays a crucial role in protecting artists' rights, because we can agree on anything, or we can agree on a good thing in a contract, or we can agree on a bad thing in a contract. So I have prepared some legal analysis to key elements that we should be aware of and should be considering when drafting. We have different kinds of contracts: commission agreement, gallery contracts, especially. important, I think, here a contract with the museum, with the other person that wants you to create the work, publishing contracts maybe, and license contracts, which are pretty exceptional here and are important and concerns when the artist is granting the permission to other party to use their work. Okay, so before I was telling a little bit about the transferring the right and about the licensing the right. So this is the situation when the license agreement is a separate agreement only talking about licensing the right, but license agreement can also be the part of another type of agreement, like publishing contract, like contract with galleries. So you should know that distinction. And key types of licenses is exclusive license, when the only party has the ability to use your work. Non-exclusive license, when you have many clients and you give the license to multiple parties, or you have like open license, for example, in this platform like Creative Commons. So it's also possible. And maybe just try to move through the key elements of solid contracts, because for a contract to be legally binding, legally enforceable, and artist friendly should include several very essential clauses. Should be very good identifying the party. Believe me, it's very important who is put it in the beginning of the agreement, whether it's the proper site or person or entity, because at the end it may occur that you cannot do any legal actions because it's not the good part of it. And very important is to put the scope of the work in this agreement, to pay attention to the payment terms and compensation for damage, for example, to take care of the intellectual property rights. And as I was telling you before, you need to clearly state who owns the copyright, whether the copyright is transferred, whether you give any license in that matter. So that's very important. If you give the license, you have to also give the exploration areas that are need to be pointed out to what purposes your work will be used. Duration of the contract is very important issue, and dispute resolution, how to will be solved if some discussion will occur, whether you go to the court, whether you go to the arbitration, for example. And what to do if someone is breaching your contract or stealing your work, do anything, not paying you, and just infringe your legal property rights. Well, you have to add for sure, and firstly be aware what is happening. You have to review the contract. You have to write it. You have to read it very carefully. And if you have any doubts, you should always ask about help. That you should look for support in areas. You don't have to be paid support. It doesn't have to be always lawyer. Maybe it could be some institution that help artists in this matter. With the contract, I'm sure it's very many ways to do so. And after that, you could, as I mentioned, regarding the copyrights, you can always talk, negotiate, settle. You could try to do anything to be successful before the legal proceedings. You can, of course, send the correspondence to formal notice of breach, to demand the letter, to demand the payment for infringement. All that stuff can be made. You can even change the agreement, okay? If you start to discuss and start to talk with other party person that is infringing your contract. And of course, at the end, you can take the legal actions.